We're going to go ahead and get started. This is our Board of Adjustment training session on Tuesday, May 24th. So we're going to start with introductions of everybody that's in the meeting, and then we'll talk a little bit about what we're hoping to do with you guys today in our training session. So my name is Elisa Hamblin. I'm the zoning administrator for the city of Tucson. I've been in this position just a few short months, so I think I've mentioned to y'all before that I'm still learning the role of the Board of Adjustment and my place with it, but I'm excited to have a really good group to work with. You all have been great so far. And we have a really good staff that supports the Board of Adjustment, and I'm happy to work with them. So I'll go ahead and let Mark introduce himself.
I'm Mark Castro, Principal Planner with the Zoning Administration Division. So I supervise our staff that help support the Board of Adjustment to make sure the meetings get scheduled for, make it to the agenda, as staff reports are completed on time, and is getting legal advertisements posted on time as well. So we take care of that to make sure everything is properly noticed, and that we do have a hearing that is meets all the requirements. Glad to help out.
Thanks, Mark. Go ahead, Perry.
Hi, my name's Golinski. On the email, you're going to see my full name, which is Piroshka, which I don't use for obvious reasons, because it's too hard. I've been with the city longer than I like to admit. I started in 1998 at the prosecutor's office. I came over to the civil division in 2013. I do primarily the zoning and planning and representation of the main representative for the Planning and Development Services Department. I staff the Planning Commission and a number of other boards, committees, and commissions, except the Board of Adjustment. I am currently the backup for the Board of Adjustment. So if Roy is gone, like he is on vacation, I'm backing him up today, and also training Jennifer Bonham, who's my colleague and new attorney in our office. So I'll let Jennifer introduce herself.
Good afternoon, everyone. My name is Jennifer Bonham. I'm an attorney in the civil division here. I've been in the civil division about a month. Before that, I was at the Attorney General's office doing civil litigation in the consumer litigation unit. And I'm looking forward to working with you all.
Thanks, Jennifer. We also have two of our other planners here who have not shown their faces, but I'll just let them briefly introduce themselves and say hi. They're learning about the board as well because they're relatively new.
Hi, my name is Wyatt Berger. I've been with the city for almost a year. Essentially, my function with the board is helping out Mark with some of those processes that are required. And this is my first training session, so happy to listen in.
Hi, I'm Georgia Pennington. I'm a planner as well with zoning administration. And I also help out Mark with the Board of Adjustment. Nice to meet you all.
Thank you. Michael, you want to introduce yourself?
Okay, my name is Michael Marks. I'm on the board for maybe a year or maybe a little bit longer than that. A period where there's not been a lot of activity. It's kind of sporadic, you know, sometimes a few cases, sometimes some months go without any. The entire time I've been here, we've been conducting hearings by way of Zoom. I'm looking forward to that being a matter of the past, and so we can see each other and the applicants and any other parties involved face to face. I've been involved in, well, the sign committee for some period, and then other matters related to the planning field where I've been involved in face-to-face hearings. I much prefer that. I'm the chairman, but just one other member of the committee. So I think that's all I have to say.
Last but not least, Kathy, do you want to introduce yourself?
Sure. My name's Kathy Kubish. I've been on the board maybe 2 or 3 months long vice chair. My background is mainly with the Pima County Assessor's Office. I was a draftsman, a residential appraiser, and a land appraiser for 30 years altogether. And I'm amateur and volunteer other places, among them this Board of Equalization.
All right, thank you all. So for our training session today, Mark did send out a packet of materials. It is 67 pages. I acknowledge that's a lot, but some of it is just for informational purposes. We're not going to go through all of that word by word today. Obviously, that would be too much. So we're really going to try and hit the high points, things that we just want to make sure everybody knows, or where to find the information and how to get the answers maybe that you're looking for. So and the main things in the materials today is there's a presentation from Mark that's a welcome presentation. There is a few pages about Robert's rules, or how to get or how the meetings are conducted. There's some board training, or the board rules, which is generally how we conduct ourselves as the Board of Adjustment. There's some information about legal framework, meaning, you know, why does the board even exist, and some prior case law that kind of sets some precedent for us. And then Mark has some example cases we'll talk through, and the findings, and how to make decisions with appeals and variances. So that's a rough outline of the agenda. Mark is going to share his screen and pull up the materials just so we can kind of follow along. If he does reference a page number as we're talking through the materials, the page numbers are the ones in the upper right-hand corner of the materials. They're in green. It'll say like page 1 of 67. So you can follow along as needed. And then I'm going to be taking notes of any questions or, you know, topics that come up as well. So Mark doesn't have to do all of that on his own. But as I mentioned, my internet's been a little bit spotty today. So if I disappear, I will come back into the meeting. But my role will be kind of to take some of the notes as we kind of move forward. So we have an hour and a half set aside for the meeting. We'll see how much of that time we need. I'm sure we could all talk about the Board of Adjustment for hours and hours easily, but we'll try to end on time and be respectful of everybody's time today as we kind of move forward. So Mark, go ahead.
Okay, so can everybody see my screen? Are we good? Okay, all right, thank you. Okay, so first topic we have the role and conduct as a board member. So in the past, when we were meeting in person, we would go on field trips. And it was a benefit because we all got together, met at a location, and then we would have the cases, some of the case information printed out, and we would bring copies of the site plan with us, you know, for the project. And we would go as a group to these locations. And the purpose of the field trip is really to get, you know, get us out there to take a look at, put things in perspective. We look at the property and then what is being proposed, and then kind of see how, you know, how the neighborhood is. And that may be drive through a few streets, you know, in and out of the neighborhood to kind of just do a window survey of this. And the whole time, you know, there's questions being asked about what, you know, what's the process, or, you know, can they do this? And, you know, some of those questions are legitimate, or are we consider, you know, legal questions. And then some of them are questions that you shouldn't be asking. We actually hold on to those questions until the actual public hearing, because we don't want to discuss the merits of the case. So when we do a field trip, you can ask for like clarification of a code requirement or something something that needs clarification in the request, but it can't be anything where it's leading to an opinion, because we don't want other board members to feel like you're forming an opinion about what decision they may be thinking about already. So those are the kinds of things we want to try to avoid when we're meeting. Say we do this in the future, where we do go on field sites, and if we're meeting, we want to make sure that we watch what we're asking, what we're talking about, because this becomes a open meeting violation, and that's something that will be covered later on. Study session and the hearing, again, that's separate things, but the study session, again, as you all know, it's the opportunity for staff to go over the project, what the variances being sought, what staff's position, and approvals and protests that have been received. And again, the purpose is to clarify anything that the board may have questions about that staff can answer. And again, it can't be anything that should be discussed at the public hearing. So if it's going to be clarification on a code requirement again, or something like that, or process, those are the kinds of questions that can be brought up at study session. The hearing itself, that's when, that's the appropriate time when the case is closed, or during the testimony when there's questions from the board for either the applicant or for the person who's speaking in favor or in opposition. The board's allowed to ask questions. And then also, then after the close of the hearing, there's also that opportunity where the board can discuss among each other, their thoughts and clarify anything or have questions. So that is what we need to be aware of when we're all together in these group settings. Just remember to watch the type of questions you're asking and your discussions. So as you know, Robert's Rules of Order applies, and so it's really just the framework of how a board should be run. So I'm going to go ahead and refer to, let's see, find that page here. So yeah, essentially it's the procedures of how a board should run. There's a lot of good information in here about when to introduce a motion, how to change a motion, what the appropriate language is, or when it is appropriate to ask for it. And there's a cheat sheet here, what you want to do, and then what you would say. So this is good information to have handy. So just wanted you to be aware of where this is located at. So if you scroll through this information here, it should cover a lot of motions and points of order, things that I haven't seen brought up, but I'm sure in other meetings it may have, but it's there for you to reference. Does anybody have any questions at this point, Kathy or Mike?
Yeah, I do. I had one when you spoke about field trips, and I think I know the answer, but I just want to ask it anyway, and that is, do we have any legal rights to enter onto a property if we can't see the subject of the variance from an adjoining street? If, for instance, there's a side yard matter that is remote from the front street or the alley behind it or what have you, if we can't enter onto the property, we can't really see the subject.
That's correct.
I assume we have no such legal rights, but I just want to ask the question anyway.
That's correct. Yep, we don't have any legal right to enter their property.
Okay,
And so what we've done in cases like that, it's kind of looking, you got to take into consideration how the neighborhood exists, and kind of, there's things that you can see, maybe there's things that you noticed on other properties that might be similar to what the applicant is going to be requesting. So those are the kind of things, but it is beneficial sometimes to, I can your point, yeah, sometimes it is best if you can get on the property. But no, we are not allowed to, we don't have any legal right to get on the property at all.
okay. I have a question on all the motion, subject to the motions. I don't recall a case or an instance where we've had an amended motion or a substitute motion. I think in every case, there's been a motion made and it's been seconded upon, and we voted upon that motion. But just for clarification purposes, if there is a motion and it's seconded, are we obligated to vote on that if a third member of the board interjects that they wish to offer a alternative or an amended or some other form of motion at that point?
I think it has to be done before the motion is seconded, but I think Perry.
Yeah, I can interject here. There are specific rules for making substitute motions and friendly amendments to motions that have been made. And I have not looked at the rules with any particularity. Are those motions mentioned in the board rules? Lisa or Mark, are you aware? Because okay, so my point being, you look into your rules first, and I'm thinking Planning Commission. Planning Commission has a section on a little section on parliamentary procedure, but doesn't look like it. So in the absence of any parliamentary procedural rules in the board rules, you would default to Robert's rules. Robert's rules, when you're making a substitute motion, so a main motion has been made, and then a motion is, and then that motion is seconded. But before a vote on the main motion, somebody can make a substitute motion. And
so if somebody makes a substitute motion, does that have to be accepted by the maker of the original motion before there is action on the substitute motion?
it doesn't have to be accepted, but it has to be voted on before action on the main motion. So a friendly amendment has to be accepted.
What's the difference between the two?
So there, it's basically an amendment is more of a request to amend a motion versus like make a whole different kind of motion.
Mm-hmm.
So I just want to tweak one word. Would you accept that? And then you can accept that and then vote on the main motion. Whereas a substitute motion is, I want to make pretty much a substantially or substantively different motion than what has just been made, seconded, and discussed.
So either of those two forms could be offered after a main motion is made and seconded. And is it in both forms of change that there would be a vote to accept that substitute or amended? And if the vote carries, well, if there's a substitute motion that carries, then that replaces the original motion, correct?
Correct. Main motion is dropped at the point in time that the substitute motion is voted on and approved.
If there's a friendly amendment, which is a simple modification, a 10 versus a 12 or something like that.
Right.
And if it's approved, is it voted upon by the whole board, or is it just accepted by the maker and the seconder?
The motion maker has to accept it, and then it's approved by the whole board. You have to accept that. It's your motion. I accept your amendment, and then the whole board votes on that as the main motion with the amendment.
Okay, okay. Thank you. Thank you. That clarifies that.
You got the difference there?
I do.
Okay.
Yeah, no, thanks.
Okay, so to clarify then, a motion is made and seconded. And if someone on the board wants to make a substitute motion, that is done after the first motion has been made and seconded. Is that correct, Elisa?
That's correct.
Yes.
And then that
And then
motion,
the
the
substitute
substitute
motion-
motion has to be voted on before the main motion can be voted on again.
Okay, so the substitute motion then is that correct?
I'm sorry, Kathy, you kind of, I couldn't hear you. Can you repeat it? You broke up.
Sure. Oh, so we have a main motion which has been seconded. We have a substitute motion which has been seconded. The seconded vote or seconded motion needs to be voted on prior to the main motion or takes the place of the main motion. Is that correct?
So once the substitute motion is made and seconded, if it passes, the main motion dies. If it fails, then the main motion
Okay.
can be voted on.
Okay. I have another question. Are you able to hear me still?
Yes.
Okay. And this is on a different subject. Mark was referring to field trips. And so at that point, are the members of the board not supposed to discuss their positions on the motion with other members of the board? Is that what I'm understanding? We do not discuss it among ourselves. Is that correct?
Kathy, are you talking about when the board is together other than in a public hearing setting?
Well, I think the only time we're together would either be the theoretical field trips or in the study sessions. I mean, when we can meet face to face, that's a different matter. But my main question, I don't really understand whether or not the board members can discuss the case with each other, or if we're supposed to all be keeping our own counsel about it.
Right, you're not supposed to be discussing the merits of the case with each other unless you're in the public hearing setting. So when you're at study session, you may have a separate question about, let's say it's a setback variance. You know, it has to do with maybe what's in between the property lines or something like that. And then you find out it's some rose bushes. And then maybe in your opinion that, you know, the setback reduction is going to affect the rose, you know, affect those rose bushes. Whereas maybe the other board member may not see it that way. So we're just, I guess the point is that you want to just ask the specific questions like, okay, what is so what is in between the building and the property lines with rose bushes? Okay, and then kind of just leave it at that rather than going into further with saying, well, I think it's going to kill those rose bushes, and therefore, I don't think this variance is supportable. So do you see what I'm trying to get at, the difference?
So you want substantive questions, not opinions
Right,
during the study session.
right.
Okay. And then, okay, thank you.
Sure. And Lisa, you have a question?
I don't have a question. I have two comments. It looks like Miranda joined us a little bit ago, so I just wanted to recognize that she was here and give her a chance to introduce herself real quick before we move forward. So if Miranda, if you're able to just say hello and tell us a little bit about yourself. Oh, nope, she put in the chat her audio is not working, so I don't even know if she can hear me. So that was just now she said that, so hopefully she'll be able to get that going.
Okay.
She said I can hear but can't use my mic. Okay, well, welcome Miranda. We're happy that you're here. Sorry for the technical difficulties, but we are recording everything. Thank you. Okay, so the other thing I just wanted to mention in relation to Robert's rules, and Puri kind of alluded to this already, is we have our own set of rules for the board that have been in place. They get amended sometimes, so they're in our packet as well. Robert's rules is what you default to if your board doesn't have specific parliamentary rules. So we don't really have that, so we just defer to Robert's rules. But as a board, you can alter those rules if you want to make something that's more specific for what functions for you guys. But for now, like Robert's rules is kind of what you just want to become familiar with. And the other kind of caveat to that is Robert's rules can feel really structured and kind of like a little bit stiff sometimes. I think the goal of them is to help make it clear like what the expectation is between board members as you're kind of moving through a meeting so that it makes it easier and not harder. So just so there's like a same way that we always handle a motion and we always handle a vote, so that just everybody knows and it doesn't come up for debate every single time you're in a meeting. So that's just the other little tidbit I wanted to add in regarding Robert's rules. Thanks, Mark.
No, thank you, Lisa. So I think the next item we have on our list is virtual meeting decorum. So essentially, I think everybody is familiar with Zoom enough. So, the main points to remember is that when you're not speaking, to make sure that you do have yourself muted. And when you do decide to leave the room, or you're just getting up, to get like a drink of water or something, just make sure you go ahead and turn your camera off. So that way people don't see what's, behind you after you leave or anything like that. So it just kind of keeps it looking professional. So just those couple of things, remember. If anybody is curious, I do happen to have a quick Zoom tutorial. I'm not sure if we have time, but it's like only 6 minutes. If anybody would object to watching it, or do we want to just move on?
Maybe
So that video is on what, Mark?
Just Zoom, just the basics, how to navigate through Zoom.
Well, is that something you could attach to an email to us all so we can watch that on our own?
Absolutely. That's a great idea.
Okay.
And if we get done a little bit early today, Mark, we can certainly do the video too, and if people want to keep watching, they can do that.
Okay.
Together.
That sounds good. Okay.
Awesome.
And so the other thing, just want to remind everyone, I know that we all have busy schedules and we all got other things to do rather than Board of Adjustment. there's the, so when I do send out emails asking for a quorum check, it's really helpful to me to know if you can respond as soon as possible to let me know if you are or not able to attend, just so that I do have time to work on the agenda if it's going to be this month or if I need to postpone it to the following month. So it helps me in preparation and scheduling. So yeah, if you could just, make sure that you're aware of that, that we do have deadlines, legal deadlines we do need to meet. So it's important to know that if we are going to be able to have a quorum or not. A response would be very appreciated. So, and I know you're all doing your best. So, and so far I don't have any complaints, but I just want to put out just a reminder out there. So thank you.
Thanks, Mark. And I just added in the chat that regarding the prior conversation about amendments and motions, on page 12, there's kind of a flow chart that shows that for everybody too. So that might be helpful as you're going back and kind of learning on those things. So the next section of our agenda is the legal framework of the board, which is going to be Piri and Jennifer. I think we're going to start on page 13 with that, Mark, if you wouldn't mind navigating there. That is an explanation of the role of the board and the principles and some of the legal stuff that serves as the foundation of why the board exists. So with that, I will turn the time over to Puri.
Okay. Yeah, I just want to add, I'll go ahead and copy a page out. This is back to Robert's Rules and Parliamentary Procedure. Just for those two specific rules that you asked about, the substitute motion and the friendly motion. So there's kind of a nice blurb in there that's written up, and I'll give that to Elisa to pass along to the board members, kind of a step-by-step on how to handle both substitute motions and friendly amendments.
I've got a comment on that subject. I could add, I know we want to keep moving, but as a chairman, I think the tendency is when there's a motion and seconded to go right into a call for the vote. But I kind of think there ought to be a pause to allow somebody who wishes to make that substitute motion to make it before we run into that vote. I don't mean to delay it by a significant amount of time, but there ought to be maybe a second or two before I call for the vote, just so that if somebody wishes to make that substitute motion or friendly amendment, that I'm not speaking over that member, when they blurt it out. So it's just something I guess I should keep in mind to allow for that opportunity.
Yeah, I think it's just human nature to not like quiet, spaces during a conversation. And if there's no conversation or back and forth about a motion, tendency is just to go ahead and vote on it. I don't see any problem with you asking, are there any amendments or substitute motions to be made? And there being none, let's vote on the main motion, you could certainly put that out there.
Okay, good. So, that makes sense.
Yeah. So I'll go kind of quickly through the material. I think you're probably all pretty much familiar with your role, but this is just kind of give you some background on the legal authority, where the board derives its authority from, and specifically what the board is. And you are the Board of Adjustment, considered a quasi-judicial body in that you apply the law to the facts. You hold public hearings, you administer oaths, you take evidence, you weigh the evidence, and you apply the law to the facts of the case and draw conclusions, much like a judge would during a trial. You're quasi judicial in that you don't have as much authority as a judge, so you don't have subpoena power. You can't hold witnesses in contempt, things of that nature. But your role as a fact finder and a decision maker is much like a judge. And you are applying the findings and the law, the UDC, to the facts of the case, just like a judge would. It's the board's role to give meaning and spirit to the UDC as enacted by the mayor and council. But you don't have authority to make laws, or so you may not agree with a provision of the UDC. You may not agree that the variance before you, is a good one, but your role as quasi-judicial officers is to apply the facts to the law and to uphold the granting of the variance if it meets the findings, whether you like it or not. If there are provisions in the UDC that you don't like, you can always, as members of private citizens in your own capacity, suggest changes to your council member or to the mayor and council, or suggest to staff that some provision in the UDC be changed. The underlying principles for variances, as listed here, the zoning laws should be applied uniformly to everybody. Variances exist, however, because of the unique or special circumstances applicable to a property, such as its size, shape, topography, or location, mean that the UDC requirements may not fit this particular property. The granting of a variance allows flexibility so that a property owner who finds themselves in a situation where, because of the size, shape, or topography of their property, will be unfairly deprived of the use of their property, such as that their neighbor can use it in a way that they can't. So the variance gives that property owner the ability to utilize their property in the same manner as other property owners within the same zone, so that it can be used uniformly. But it shouldn't give the property owner an advantage over their neighbors. So that is an underlying principle of why variance is made available and what your role is in interpreting whether or not it's appropriate in any given circumstance. The legal authority for the Board of Adjustment derives from the Arizona Revised Statutes, specifically Title 9-462.06 and specific case law, which is in your materials and some of which I'll go over later. Your authority is to grant variances and to hear appeals from like tomorrow, zoning administrator determinations and other appeals that are listed as appealable to the Board of Adjustment within the UDC. Don't know those off the top of my head, but I think they're mentioned elsewhere in the material. As a quasi-judicial body, you provide due process to the applicants, and in providing that due process, there's notice of the public hearing. There's an opportunity for the applicant to be heard. There's an opportunity for the applicant to present witnesses and to confront the adverse testimony against them. So the protests get to speak, and the applicant gets to address that. And in that manner, they receive due process and they get their day in court, quote unquote, before you all as judges. You listen to the testimony and the evidence at a public hearing. Your role is to reserve judgment until you've heard all of the facts and all of the evidence, and to uphold the decision or to grant the variance if there's credible evidence to support your decision. Whether or not you like it, your job is to enforce the law. There are some limits on the board's authority. The board is prohibited from making changes in uses permitted in any zoning classification. So for instance, you're probably never going to see any of these cases before you because it'll get stopped by staff who won't even allow the application to proceed to a hearing. But that basically means, you know, you couldn't grant a variance to allow an industrial use in a residential zone. That's what that means. You can't, the board should not be granting a variance if special circumstances applicable to the property are self-imposed by the property owner. And we'll go over that in relation to some of the cases that we discuss later. So if you're the one who creates the hardship on your property, you don't get to ask for a variance, and the board should not be granting a variance if you've created your own hardship. The board cannot grant a variance to any administrative requirement of the UDC. I would say that's like, you can't grant a variance to not pay a $50 fee or things of that nature. And you can't grant a variance to use specific standards required of an educational use, or delete or vary any use specific standards applicable to a special exception land use, or as established as a condition by a decision-making body in the granting of a use. So in other words, you can't change a use specific standard unless the UDC grants the board the authority to hear that variance. Some other of the limitation, I'm sorry, did someone have a question?
Can I ask a quick question? Going back a section or two here that you've been involved in, you've indicated that the board can deal with an appeal of a zoning administrator decision.
Correct.
That's very clear when the zoning administrator has written a letter declaring a position. But does that extend to somebody that in the organizational chart works for the zoning administrator that might have made a decision, let's say on the first floor, involving a permit request? Can one appeal a decision by a zoning compliance planner under the guise that's a zoning administrator decision, even though it never really was directly involving the zoning administrator?
So I'll try to answer that, and Elisa may want to jump in, but I mean, the short answer is no, because there's a process by which one has to apply for and pay for a zoning administrator determination, and that's a process that is outlined in the code. So no, you can't just say, well, I asked for somebody to answer my question about this, and when they did that, they offered me an interpretation of the code and I don't agree with it, so now I get an appeal. You have to apply for a formal zoning administrator determination and pay your fee for that before you're entitled to that determination. And once that determination is made, that's when your right to appeal would kick in.
Okay.
And I would just add to that, and we'll talk about this a little bit more in a minute. There's different kinds of appeals which the board will hear. The one you're most typically going to see is an appeal of a zoning administrator determination, like the one tomorrow, where there is a specific letter and the appeal is about that letter and that determination. So there can be other appeal types that are for certain types of uses that are specifically outlined in the UDC. I don't know that the situation that you're describing would really be an appeal to the board necessarily. I think if someone had some kind of incorrect decision by like someone reviewing the plan, it would typically go through a determination process first. Like it would be skipping a step if it went straight to the board. It would need to go to the administrator to make a determination first if the person in question did not like the answer. And then again, we'll cover the other appeal types briefly, but for reference, that is on page 61 of the materials. It just lists the different kinds of appeals, but we'll get back to that.
Okay.
Yeah, and those appeals are listed in the UDC. It will say, from this type of decision, you may appeal to the zoning or the Board of Adjustment. Or it might alternatively say, from this type of decision, you can appeal to the mayor and council. So it specifically tells you what administrative agency you get to appeal to in the UDC based on the decision that they make.
Okay. Very good.
So getting back to variances, some of the limitations on the board's authority to grant variances, again, getting back to if you just don't like it, that's not a valid reason for not granting a variance. The benefit, attractiveness, or social desirability of a project are irrelevant. You want to look at the property, you want to look at the standards, and you want to look at which findings are or aren't met and apply the law to the facts. You may not like it, it may not feel good, but if the law applies, then you have to uphold the granting of the variance. Special circumstances and hardships justifying the variance must apply to the property, not the applicant. We all have friends, we all want to help them out. Obviously, that doesn't affect whether or not their project or their application should or shouldn't get a variance. No arbitrary enforcement of who should or shouldn't get the variance or who to whom or not the UDC should apply. Economic hardship alone does not justify a variance. So we'll go over a case. I think it was Arcule's case. They wanted to put a third floor on, at the time it was Levy's at the Elcon Mall. And the variance was, I believe, granted in the beginning, and then that was appealed, and the appeals court, found that they didn't have to have a third floor. The main reason for wanting a third floor was that the department store had grown and wanted to make more money and provide more jobs to the community, but that was not, economic hardship did not rise to the level of hardship as defined in the statute for purposes of granting a variance. It's the board's responsibility to ensure the laws applied equally, and that variances should be granted sparingly and under exceptional circumstances, but as you apply the findings. With regard to appeals, the board's decision can only be reversed upon a showing that the board acted in an arbitrary and capricious manner or abused its discretion in making its decision. So a court will look to your findings, which is why it's so important that they're always part of your motion and that they incorporate the findings in the staff report, that your decision incorporates the findings in the staff report. And they will look to how you applied the facts to the law, to the UDC. And if there's reasonable application of the law and the facts to satisfy the findings, the court will find that you did not act in an arbitrary and capricious manner. It's when you throw reasoning and the findings out the window and you make a decision based on how you feel or because you think it's not fair versus a strict application of the facts to the law is when you might be found to have abused your discretion and acted arbitrarily and capriciously, which basically in a nutshell means unreasonably. Meaning there's no foundation in the fact or the law for your decision. There is a case which I've cited in the materials under paragraph number 7 that attempted to define abusive discretion for administrative agencies, and I'll just read it. In determining whether an administrative agency has abused its discretion by acting in an arbitrary or capricious manner, the court will review the record to determine whether there has been, quote, unreasoning action without consideration and in disregard for facts and circumstances. Where there is room for two opinions, the action is not arbitrary or capricious if it's exercised honestly and upon due consideration, even though it may be believed that an erroneous conclusion has been reached. So what that means is that the court will look to see that you reasoned through your decision and that you came to your decision as a result of your reasoning. Even if they disregard, even if they disapprove of the result that you came to, your decision should still be upheld by the Superior Court if they find that you didn't act arbitrarily and capriciously in coming to your decision. So in other words, the reviewing court should not be reviewing your decision and inserting their own thought processes into how you got to your decision. They might not like your decision, but if you had a reason for reaching your decision should be upheld by the Superior Court. So I know that's kind of a mouthful, but that's the standard. That is similar to the standard that will be applied, and we'll talk about it more tomorrow, when you are reviewing the ZAD's decision. And then one of the final things here is just the role of the city attorney's office is to support staff and to offer legal advice, mainly during the hearing on parliamentary procedural type issues during the meeting. And if there are any legal considerations that may come up in terms of jurisdiction, does the board have jurisdiction to hear this? What is our role? Things of that nature, but it's not our job to tell you how to reach your decision or to make the decision for you or to tell you whether your decision is proper or not, or whether we do or don't agree with it. We're just here to help you sort of run the meeting and make sure that the meeting is run within the legal parameters as set by statute. So I know I've been kind of talking at you for a long time. Does anyone have any questions based on what we've covered so far?
No, I don't.
Okay. So we can go kind of quickly through.
I have a question.
Sure.
Yeah, I when we are voting yay or nay on whether or not to approve a variance, are we not supposed to give a opinion or a reason why we are voting the way we are voting? Shall we, when the vote is taken, do we simply say yay or nay? Or are we allowed to speak at that point?
Mark and Elisa, I think you're probably going to want to weigh in here, but the motion templates that are given to you should help you in terms of making sure that your reasons are incorporated. But I would definitely advise you to go ahead, and the more reasons that you can give for either in support of your decision are all going to be considered by a reviewing court.
And just to add to that, so, right, the motion templates are provided for you so you can easily cite what the variance request is for. And then it goes through that per paragraphs or pages 3 and 4 of the staff report, that the variance request is found to be in compliance with the following findings, 1 through 7. That at that time you can cite a specific finding that you feel the variance request really substantially meets. Like, let's say it has to do something with the special circumstance. Like, everybody knows that this property has some significant topographic features that prevent it from meeting code. So that is your opportunity to kind of solidify your opinion or your reasoning why you're voting the way you are. You can say, as per finding number one, that the property does have significant topographic issues and warrants the approval of a variance. So that, yes, you can do it at that time.
Okay. And conversely, if I vote nay, I'm allowed then to state why I am voting against the motion. Also true?
But be sure to cite the finding that you find the reason why you're voting for not granting the variance. So just maybe you do cite that. So we have that on record. If it should be appealed to Superior Court, we know what finding you were finding the project not in compliance with.
Yeah, I think the only comment I would make on this subject is that we have the findings and they're incorporated into the motion.
Mhm.
And so should a motion pass, we all have signed, all those who have voted in favor of the motion have signed into the findings as stated along with the motion itself. But if we individually were going to then express why we personally were in favor of the motion, and we came up with different reasons, I'm not sure how that helps in the subject of an appeal, because there is no there would be no unification at that point. There would not be any commonality to how the board acted. So I know that these hearings are presumed to have discussion periods, but we actually never have them. I mean, I do make that comment or ask that question. Is this is a time for discussion and a motion should somebody wish to make one. But, when you consider the value of discussion in the context of defending an outcome with an appeal, I'm not sure what the value of that discussion is if each person comes up with something different.
I should clarify.
It would be more like,
I'm sorry.
it would be more likely that, go ahead, Mark.
I'm sorry. Just to clarify, whoever the motion maker is the person that can, identify a specific finding. I didn't mean necessarily for all of the board members to weigh in with what their thoughts are at a specific finding. What I mean was that the motion maker, whoever reads the motion template, has that opportunity, if they desire to cite a specific finding and provide an example of why. So I just wanted to make that clear.
Okay.
I think, Michael, what you're speaking to is correct, that the time for saying, well, I agree it meets this finding or that finding, but not finding, I agree it meets finding X and Y, but not Z. And I would be willing to vote yes on a motion that would approve this for having met X, Y, but not Z. That's the time when you would have your debate, but the ultimate motion, everybody has to vote on that and agree on the final motion.
Mm-hmm.
So I'm not sure if that answers your question, Kathy, but I think the time for saying when you do and don't agree with everything or a portion of everything is during discussion. But when it does come to a final vote, everybody does have to be in agreement on the motion as presented by the motion maker.
Okay, so any discussion, any objection, any reason why you do not agree with the request to grant a variance would be held more properly during the discussion and not during the vote. Is that right?
That's correct. And your option would
Okay.
be to vote no if you aren't agreeing with the motion that's on the table.
Okay, right.
So we'll just move on to some of the cases. So I was wrong earlier about the Levy's. Arcules is a case about color. The takeaway is that the hardship must relate to the use of the land. A personal hardship doesn't justify a variance. In this case, the landowner wanted a variance from the requirement that his house be painted a color that blended in with the mountainous landscape, and he wanted to paint his color white. The board ultimately granted a variance to allow the homeowner to paint their house white. This was appealed to the appellate court ultimately, which found that no, in fact, the variance was improperly granted because it was a variance for a preference for a color, which is not a hardship relating to the use of land. It's more of a personal preference. And so in that case, the variance was not justified. I mean, in my opinion, that never should have even gone to the Board of Adjustment, but somehow it made it there. So Rivera versus City of Phoenix, out of Phoenix in 1996 was a case where the code limited square footage of an improvement to 25% of the area of a lot. The homeowner submitted a permit or an application and plans that erroneously indicated that the improvement would meet that requirement, but it was wrong. The city issued a stop work order and the landowner filed a request for the zoning variance to allow the larger build out that didn't actually meet the code. And in overruling the granting of the variance, the court found that the property owner did not meet the condition for obtaining a variance because he created his own problem by providing the city with an erroneous site plan. So in effect, he created his own hardship in that case. Burns versus Spa Automotive is a case out of Scottsdale from 1998, in which a new car dealership's application for a variance to erect a freestanding sign that was larger than that permitted by variance was overturned by the court. The Board of Adjustment had granted the variance to allow this larger sign, but found that because of the way the dealership was constructed, the need for the larger sign was created by the car dealership owner, and that therefore it was again a self-imposed hardship and the variance was improperly justified or improperly granted. Haynes versus City of Tucson is a case from 1989, has to do again with the landowner creating their own hardship. The landowner had purchased property that was zoned commercially and wanted to build a restaurant there, but because the building design was so large, they didn't have enough property left to provide the required number of parking spaces. And in overturning the granting of the variance, the appeals court reversed the variance, holding that the landowners were not entitled to the variance from the parking space requirement for the not yet constructed restaurant because it was a self-created hardship where the owner had wanted to have a larger building than he needed to have and therefore had created his own problem with the parking spaces. Ivankovic was the case involving the Levi's department store, and that was a case where the opposition to the owner of Levi's department store requested a variance to build a third floor up to 51 feet 4 inches. The code maximum was 35 feet. All the witnesses in favor of the variance, including the property owner and the store owner, testified as to the economic benefit associated with having a third story. They also testified that there was money to be lost, in that there was 15% loss of business due to overcrowding. That the third floor would not affect the view shed, the light or air of the occupants or the nearby residences, that there was adequate parking, that there was fire protection, and that the Levy's store had outgrown their space and needed to expand, and the expansion would create more jobs and add to the payroll. Variance was granted. That was appealed to the Superior Court. The Superior Court upheld the granting of the variance. It was then appealed to the Court of Appeals, who ruled that the variance should be overturned and that the inability to put the property to a more profitable use or loss of economic advantage was not sufficient to constitute an undue hardship on the part of the property owner, and that the variance had been unduly or improperly granted. Pond First was an interesting case out of City of Phoenix in 2017. The facts are kind of a little bit complicated than usual, but in effect, what happened was a property owner bought a property and wanted to have a pawn shop at that location. It was in an area that allowed for pawn shops, and there were in fact other pawn shops in the area, but they couldn't meet a 500-foot residential setback because the city had completed an eminent domain action that had altered the property's dimensions and therefore put them within 500 feet of this
So it looks like Puri's computer might have frozen. So we're going to go ahead and move on. Hopefully she'll be able to join us back in a minute. But I recognize that we're running out of time and we have not gone through quite a bit of the material today. So what I'd like to do is just reference, there's two items that are in your packet. There's the Board of Adjustment rules, which we talked about briefly earlier when we were talking about Robert's rules. That's the next item in the packet. We're not going to go through that. That's just for reference. And then the next thing is the open meeting law, which is the presentation with kind of the green bar on it. That's from
Sorry
the
about that.
clerk's
I
office.
disappeared.
Oh, Puri's back. Okay, sorry. I was just saying, Puri, we're not going to go through the next two items in a lot of detail, which is the Board of Adjustment rules and the open meeting law. But just want to make those resources available for people so you can go back and kind of take a look at them and understand the reasons why we do things the way that we do. In particular, in the open meeting law, it's been updated to talk about virtual meetings and how that, meeting on Zoom and how that works. And you'll see when Mark sends out an email to the whole board, he blind copies everybody purposefully because of open meeting law, so that we don't have any kind of back and forth over email with the whole board, because that would create a situation where we were essentially making decisions outside of the actual board meeting and making it so people didn't have their day in court, so to speak. So Puri, did you want to add anything real quick on that last case you were talking about, or do you want to go ahead and jump into just mentioning the city code and the UDC?
Just that because it was the city that had created the hardship, then the owner buying into the hardship was not considered self-imposed. Just touching on the city code, chapter 10 are the general rules for committees and boards, and chapter 24 of the city charter grants mayor and council the authority to establish such boards, committees, and commissions as deemed necessary by law. And the UDC section 225 A, B, and C, you might want to familiarize yourself with those, discuss the composition of the board, the administrative functions of the board, and the powers and duties of the board. And those will be discussed more by Elisa and Mark under these types of cases. I know we're getting short on time though, so.
Yeah.
All done.
Thank you, Perry. That was really helpful. I appreciate all that information. We're going to go ahead and start talking about the types of pieces, and Mark will talk through a couple examples if we have some time, but I'm not going to read everything that's up on the screen about the variances and appeals. And Mark is more attuned to all of these things than I am, but this is straight from the UDC essentially. And as I mentioned earlier, there's different kinds of appeals that actually come before the Board of Adjustment. They're specifically mentioned in the code, like this item may be appealed to the Board of Adjustment. So like I said, the zoning administrator determination is the most common one that you will see. And we do have a case tomorrow for that, which is again about the actual determination and the decision as part of that determination. That's the question before the board. And then there's other appeal types there. Mark, do you want to mention anything on other types of appeals maybe the board has seen in your memory?
Yeah, I would say, and to add to the most common types of appeals, I would have to say appeals on a DDO decision. Those do happen not quite as frequently as a zoning administrator determination appeal, but that seems that those do pop up. As far as the other ones, like a decision on a special exception, or what was the other one? Yeah, the neighborhood preservation zone decision appeal on that. So those are, I have not seen any of those come before the board. So they're, at least during the time I've been working with the Board of Adjustment. So yeah, that's all I have for that.
We've already briefly kind of touched on findings, but Mark, I think it might be helpful if you want to go through the main points on the findings and some of the kind of examples referencing back to some of the cases that Perry just talked about for us.
Sure. So the first finding that we have is that because there are special circumstances applicable to the property, strict enforcement of the UDC will deprive such property of privileges enjoyed by other property of the same classification in the same zoning district. So what this is essentially asking is, what is the unique or physical circumstance on the property that's preventing the applicant from meeting a code requirement? The best case scenario I can think of is, maybe a property that has a lot of topography issues, and they want to construct a detached accessory structure. And because of the topography issues, you can't build up against a hillside or something like that. They're limited into the location where they can construct a structure. Let's just say that this structure happens to be maybe towards the front street lot line, so it'd be considered a project that's in the front yard, which would require a variance. So that is an example of what we would consider a special or unique circumstance to the property. Number two kind of ties in with number one. It talks about that the special circumstance is not a self-imposed or self-imposed hardship or created by the owner. So when we have topography issues, of course, that's not something that the property owner created himself. But let's just say, for example, somebody bought a property and they developed their residence towards the rear of the lot, and now they have this open front yard space. So let's say later down the road, they want to build a detached garage, and the only place they can put it is in the front yard. That would be an example of a self-imposed hardship, because that property owner decided to choose the location of where he constructed the residence, and now he's got this open front yard lot where now he's going to need variances for anything detached. So that would be considered a self-imposed hardship. And there's also samples here citing the Rivera case and Burns case. So those are all good examples of self-imposed cases here. Okay. The next one, that the variance granted is subject to such conditions as will assure that the adjustment authorized shall not constitute a grant of special privileges inconsistent with the limitations upon other properties in the vicinity in which such property is located. Let's see this example here. If the case would give the applicant an advantage over their neighbors, the board could impose conditions to the variance that would reduce the advantages over their neighbors. For example, make the addition match the existing houses, reduce windows, cannot build two-story, no parking in the driveway. So this is a good example as provided here. The only thing I can think of is when a variance is granted, it should be, again, it's not advantageous over a neighbor, but it should also be a situation whereas if the neighbor had the same physical or unique circumstance of this property, they should be able to request the same type of variance. The next one, that because of special circumstances applicable to the property, including its size, shape, and topography, location, and surroundings, the property cannot reasonably be developed in conformity with the provisions of the UDC. So I think this ties into number one again, where they're talking about what is the unique circumstance or special or physical constraints of the property that preventing the project from meeting code. And here we cite the Hercules case, and these are good examples to reference. 5 and 6 are pretty much self-explanatory, that when a variance is granted, it should not be detrimental to public welfare or to the other property improvements in the neighborhood in which the property is located. So we want to be sure that life, safety, and health is always considered when granting a variance. We want to make sure that we're not granting something that could potentially be a health or safety issue. That the proposed variance shall not impair an adequate supply of light and air to adjacent property, or substantially increase congestion, or substantially diminish or impair property values within the neighborhood. The best example I can think of is what Rustlin always referred to as the tunnel. You have a property that's, let's say, it's got maybe 3 feet away from the property line, and then another neighbor who wants to construct a building that's also going to be maybe 3 or 4 feet from the property line. Now what we've created is this tunnel of no light, no air, so that there needs to be some kind of space between that. So that's what that example speaks of. That's the best example I can think of. And then the final number 7, that the variance if granted is the minimum variance that will afford relief and is the least modification possible of the UDC provisions that are in question. So again, this is making sure that whatever the applicant is asking, it's the minimum necessary. In other words, they've exhausted all their other options, and that this is what they need. They're not asking, let's say that you need 3 feet. You're not asking, you shouldn't be asking for 10 feet. You need 3. So that's what it really comes down to. Conditions. Okay, so the Board of Adjustment can impose conditions. You don't necessarily have to, but if you feel it appropriate, as long as those conditions relate to the variance. An example would be, let's say we're granting a setback to a structure that's maybe 3 feet or 4 feet away from the property line, and they have a window. A condition can be, let's, instead of making that a standard window, why don't we make that window frosted or something like that, so there's privacy, so there's not somebody staring out the window. So think of it that way. When you do impose conditions, make sure there is a nexus to the variance that's being asked. So, obviously you don't want to say, impose a condition for color. It has nothing to do with the variance that's being requested. Number 4, does anybody have any questions so far before we
No,
We
I
got
don't
3
know
minutes
anything
left.
going over now.
Okay.
I have a question, Mark. We had a case a few months ago where we did impose a condition, and you had just almost described it just now. The gentleman who wanted to continue use of a building that was built without permits in his backyard, and the next door neighbor who was having a problem with it, and there was a window involved.
Yep.
And we suggested and imposed a condition that he build a 6-foot block wall or continue one to effectively block off the view from the next door neighbor. How do we know? Is there any way that we know whether the petitioner actually complied with our conditions? Does anybody go check?
That's a great question, Kathy. Yes, actually, it does. Conditions and the variances requested get translated to the plans that are approved by zoning and building. So when a permit is issued, there's those conditions on the plans that show, that there's supposed to be a 6-foot tall block wall, straddling the property line if it's a shared wall, or on the property if it's not shared. But there is conditions on there in order for the permit to be finalized. They need to pass all the inspections. And in cases like this, a variance won't become effectuated until the plans have been approved and until all the conditions of the variance have been met. So there's that connection. There's that liability on the applicant to make sure that they do meet those requirements and they do follow through with the conditions.
So the building inspector, whoever does the final check, would have to include that in the inspection then?
They're just going to be checking for whatever's on the permit card. They're looking at a permit card and they're going to be saying, okay, I need to look for a wall and I need to check for a setback. And that's what they're looking for. And that's what gets translated from a plan approval to what the permits need to be, what needs to be inspected for that permit. And once that permit is finalized, and that means that the conditions have been met.
Since this wasn't, well, so the permit in the case that we're discussing would not have been for any kind of new construction other than the construction of that block wall.
Right.
Right, yeah.
Yes, they're required.
Okay,
They need a permit for the wall, correct?
okay, thank you.
Elisa?
So, yeah, I just want to point out that it's 5 o'clock. I think we can probably finish up in about 10 more minutes. If there's anybody that absolutely needs to duck out of the training right now, we completely understand. But I think we'll spend the last few minutes just talking about approvals and protests. And Mark has a couple examples with some notes, and that's the last few pages of the packet. So if you can hang on for 10 more minutes, great. If not, we understand, and you can come back and look at the recording later. Thank you.
I'll have just 1 or 2 quick questions, and I'll try to make them really brief. But Mark, why don't you continue with what you were planning on doing?
Okay. So I pulled some sample protests or sample comments from previous cases. What I keep referring to is this project here. And what this project was, it was the construction of a detached RV garage, and this was located out on the east side. So if you can imagine, a lot of open space, a lot of topography. And in this particular case, the property owner had his residence built on a pad right about here. And then he had all this open space. There was a lot of topography issues, and he really wanted to build this RV garage. But because of the saguaros, which you're, you got to protect the saguaros because of the topography and the lay of the land, the only option he really had was up in the front here. And so he applied for a variance to allow a detached structure in the front yard and also exceeding the height of 12 feet, which is the max you can build for detached. We were not opposed to the variance request because of all the physical and unique circumstances to the site. He demonstrated well that there was a septic field over here, so he couldn't build it over here. There was just a lot of issues going on with the site. But needless to say, this still received a lot of protest in the neighborhood. And I just wanted to point out that this was actually a really good protest. It talks about that this structure now, if it were to be granted, it would be really massive. And in this neighborhood, being too close to the street is completely out of character with how this neighborhood is developed. And because this lot is one of the first lots into this neighborhood, it would kind of set a, maybe not a favorable perception of the neighborhood because of the structure. So the neighbors were really concerned about it, and they were really against it. So this, but I just put this note that it was a valid protest because of the location of the project, its mass and its height issues, and that it was just out of character with the neighborhood. What happened in the end was that the applicant decided to take into consideration what the neighbors had said about the project, and he revised his plan set, and he resubmitted a set of plans with the structure located essentially in the rear. So he had to remove, or he had to relocate his septic field in order to put the structure where it was now not in the front yard, but towards the back. It still met setback requirements, and it was actually built into the side of into the hill. So it was pretty well done. The height of the garage was actually maybe about the same height as the home, or maybe lower, because of the topography and that it was built in. So it actually turned out into a really great project. And on the second round, after it was continued, but the second set of comments that came in, they were, it was like a complete 180. Everybody was, in support of it. They thought they did a great job at listening to the neighbors and responding well. So, and this one went through. But that's a good example of how a project you thought had the physical circumstances, but maybe in the neighbor's view, there was something else. There was maybe some communication or discussion that could maybe help them find a better location, which in this case it worked out. Here's another one regarding a detached structure in the backyard. And again, this is out on the east side where there's a lot of open, large yards. So what they wanted to do was construct a detached structure in the backyard. And this one was, I think it was like a 15-foot tall barn, which was completely out of character with the neighborhood. And most importantly, it was blocking a lot of views. So it wasn't just one property owner that's views were being blocked by structure. It was several property owners all had the same kind of views, and the people who were opposed to this actually had to put together a good presentation showing their views, their view sheds of what they would be looking at if this structure were built. So it was really done well. This variance actually ended up getting denied. So again, this structure would stick out over all of the other residential properties in the neighborhood. And I'm trying to make sure I stay on time here. I think the last one I have here is that project, Kathy, that you were just talking about, with the one with the storage shed that didn't get permits. So this person sent in a protest. It had nothing to do with the setbacks. It was all about the weeds. So again, this is an example of a bad submittal, or a bad submittal for comments. Because again, it had absolutely nothing to do with what the variance request was for. So Mike, I think you had a couple of questions that you wanted to ask before we end it.
Yeah, I do. I have one. The first one is, assuming that quorum is 5 and a motion to approve is made and carried, but only by a 3-2 vote. There's 5 members present. The motion does not carry. If the board does not, if there's no one on the board that offers an alternative motion right away to approve with conditions, is the matter considered to be dead and denied at that point? Or does a motion to deny have to be made and it have to be approved?
So that would be, that motion fails. So unless someone else makes another motion, then that variance request will be denied.
That's it. So we're not obligated to spend any more time with it if it fails with that initial vote to approve that fails to carry a majority or a quorum.
Right, unless, again, unless someone wants to make another motion.
Okay, good. Either you or Russell has told me in the past, as chairman, I close the hearing on my own. I don't ask for another member to make a motion to close the public hearing. So I can close the hearing when all the testimony is in. Then can I reopen the hearing on my own should a question arise during that discussion period amongst the board members that only the petitioner could answer?
I think you have to make a motion. Is that right, Puri? Make a motion to open up the hearing and have it voted, or suspend the rules? Let's see.
I would have to look at the board rules. I don't know if you have any rules for reconsideration or reopening of the public hearing. We might have to get back to you on that.
Yeah.
We'll double check the rules and get back to you.
Okay,
Mike.
okay, that's
Yeah.
fine.
Yeah.
Okay.
I wanted to just follow through on I believe your prior question, Michael. If the motion is made and the variance is denied, that's the end of the hearing. That's the end. We can't, unless there's a reconsideration on a motion because there's new evidence or something, the hearing and the motion is over. Because if a meeting would never come to an end if somebody else could introduce another motion because that one was denied. The time to amend the motion or submit substitute motions is during discussion. But once a final motion is made and voted on, and there's a vote to either approve or deny the variance, the case is over. So I'm not sure. I kind of heard the tail end of that because I had to get up from my desk for a minute, but I just wanted to make sure, because if that weren't the case, then no meeting would ever come to an end.
Yeah, and I appreciate that comment, but But take it in the inverse. Let's say a motion to deny is made initially, and it fails with only maybe a second, maybe one other vote in favor of denial.
It's still denied if that was the final motion.
Or do we afford another member the opportunity to make a motion in favor?
No, the motion is done and voted on, and the variance is denied.
I think he's asking if the vote to deny a variance fails. Or am I misunderstanding?
No, that was what I said. I said if you take it in the inverse and the first motion made is to deny, it gets a second, and so we vote on it. But hypothetically, there's only one other member that votes in favor of the motion to deny. There may be enough votes there to approve, let's say. It's just waiting for somebody to make the motion to approve.
Yeah, I just don't see, I don't see that happening very often. I mean, by definition, if a motion to deny is not approved, then the variance is approved. I mean.
But when do you have the opportunity to do the substitute motion then?
The substitute motion has to happen before a vote on the main motion. So it would happen after the second on the main motion.
Okay.
And
It
has to happen before a vote on the main motion.
So there could be a scenario where there's a motion to deny, seconded, and then another member wants to substitute that with a motion to approve. He or she's got to do that right away.
Right.
Okay. Okay. That's clear.
So we're at the point now where we have gone over my extra 10 minutes, but I really appreciate the questions and answers because that's exactly what the point of this training was, is to get clarifications on those kinds of things. So thank you everybody for your participation. Miranda, I'm sorry we couldn't communicate virtually today, but if you do have any follow-up questions or would like to reach out to Mark and I individually for anything that was discussed today, we could certainly offer you some additional info if needed. And then the last thing that I just wanted to mention is our calendar. You know, we do have a regular calendar of meetings. We are, our next one is obviously tomorrow, and then we're planning for June 29th. And I believe we have cases coming up on that agenda, or at least a case. In the future, we do plan to hold additional trainings, probably a bit more brief than this one, on very specific topics. So specifically like a DDO, which is a design development option, a request to reduce setbacks. That's an administrative process, but that can be appealed to the Board of Adjustment. That's one you might frequently see come up on your agendas. And then we'd also like to do a training about some other topics which you might see come up in your purview. But today's goal was to really just get through the meat of everything as much as possible. So if we don't have anything further, I am going to go ahead and close our training. And yes, Miranda, a recording will be available and we'll distribute that to everybody. And then we'll go back through the notes that I took today as well on everybody's questions. And if there's any clarification that we need to send out, we'll make that available to the group as well. So I think that's pretty much it for today. And I hope you all enjoy your bedtime reading of our 67 pages of training materials. Thanks, everybody.
I have one more question, a quick one for Mark.
Yeah.
Are we hearing, I believe it's C1202 tomorrow? there had been an additional note on I think the historic preservation officer weighed in, but I wasn't sure whether we were hearing that tomorrow or not.
Yeah, it's a continued case, so that's the first case we'll hear tomorrow.
Okay, thank you.
Sure.
Thanks, everybody. Have a good
Thanks,
evening.
everyone.
Bye-bye.
Good night.
Bye.